Hi everyone, welcome back to my channel and today we'll be discussing about Hindu law, nature and sources. So here before we go to the nature and sources, there are some points that we need to understand. Let's see what they are. There are some doctrines of Hindu law. These are the doctrines that the Hindu law and beliefs are based on. So one is Brahma Satyam and then Jagad Mithya, Punarjanam, Karma, Punya and Paropakar and Parapidana. So let's see what does these mean. So Brahma Satyam means God alone is real. This is the basic belief of these doctrines. All of them are the base which forms the basic beliefs in Hindu culture or Hinduism. Now Brahma Satyam means God alone is real. Jagat Mithya, the world is unreal. Now, why this concept is there? That we'll understand by Punarjanam. Punarjanam, here, the soul takes rebirth after the death of the body. That is what is believed in Hindu culture. So, Jagat Mithya, the world we see as the world right now, isn't real because the soul keeps taking birth and the world that exists now is different from what will exist later. The same is like applied for the world too. The world goes through the cycle of life and death, so it keeps on changing and it's never ending. Now, karma. One enjoys or suffers in one's birth as a fruit of the striving of previous life and birth also. So we are very familiar with the word karma. We always say the positive vibes, we need to attract positive karma. So, according to Hindu culture, we believe that it is not just the present life karma, it is also the previous life karma that determines how the life of one person will go in this birth. Now, punya paropakar. So, spirit merit is punya. So, this is a way where we are accumulating the positive karma points. So, the spirit merit of punya accrues from doing good to others or paropakar. When we do good to others, when others give us a blessing or we make them happy, we are doing a good deed, that gives us punya. Now, parapidanam. Now, sin consists of doing harm to others. So, if we are doing any act, it is believed that if it is harmful others, even if it's the simplest living being, like an ant or whatever, if it is causing harm to others, that is parapidanam, and this is a sin. So, that is the doctrines of Hindu law. Now, who is a Hindu? Let's say who is a Hindu based on these four categories. That is legitimacy. So when we consider legitimacy, a child, legitimate or illegitimate, is irrelevant here, considering who is a Hindu. So any child, legitimate or illegitimate, who are born to a Hindu parents will be a Hindu. And then from this we come to the point of parentage. So is it necessary that both the parents should be Hindus? No. It can be that either one of the parent is a Hindu and the child or the person is brought up in a Hindu community. Now, when we discuss about Hindu here, it's not just the Hindus that are brought under Hindu. It is also the Buddhist, Jain and Sikh. So here, if one of the parent is a Hindu and one of the parent is a Buddhist, still it is considered to be both Hindus under the law. We don't see any difference between Hindu, Buddhist, Jain or Sikh when we consider law legally. That is here in Hindu marriage, like we have Hindu Marriage Act or Hindu personal laws. Now, next, we have the environment or community in which one was brought up in. So, just now I said about the parentage. If one of the parent is a Hindu and the other person is a Muslim or Christian or some other religion other than Buddhist, Jain, or Sikh, then what we consider here is in which community or belief was the person brought up in. If the person is brought up in a Hindu or Jain or Buddhist or Sikh community, that person will be considered as a Hindu and will be governed by Hindu law. Now, the last one, conversion. So far we discussed about a person being a Hindu by birth. So now it is about conversion. A person can also be Hindu by conversion. So if a person from any religion converts into Hindu or Buddhist or Jain or Sikh, that person will be governed under Hindu personal law. A convert as well as a reconvert. There is no distinction between a convert and reconvert in this regard. But when we go further, we will see in some of the case laws, there are some complex principles that we deal with in case of reconvert. So in case of reconvert, they can convert back to their original religion or Hindu, but it does not necessarily mean that they have converted back to their own caste. So this will be discussed. It is a huge topic and an important topic when it comes to problems. So this will be discussed later in a later video with case laws. Now, effects of conversion. So we said that a person can be Hindu not only by birth but also by conversion. So how does a conversion of a Hindu person affect him? So here we will consider most common three headings, that will be inheritance, guardianship, and marital rights. So in considering inheritance, earlier in ancient Hindu law system, where we had the joint family system and all, where a person who is a Hindu, when he converts into another religion, he will be denied of every right he has with the family and the right as a Hindu. He will be denied every right. But this was overthrown by the Caste Disabilities Act in 1850. So now the inheritance of a convert would be regulated by the law appertaining to the new religion to which he has become a convert. Now the next heading will be guardianship. So, uh, uh, like, it's a, you need to understand that here we are discussing guardianship where there would be a dispute between the custody of the children, and not like if if a husband and wife is married and one of the parents or both the parents convert, that doesn't mean that the parents lose their guardianship of their children. But if there's a dispute, like only one of the parent converts and there's a dispute between the partners on the custody of the children, so here the parents cease to have the power of natural guardianship over the minor children if they cease to be a Hindu. So this is regarding when there is a dispute between the partners and the only one of the partner has converted. Now, marital rights. Now, change of religion by a party to a Hindu marriage gives right to the other party to petition the court for a divorce. So, if one of the partner converts, may it be the wife or the husband, it doesn't dissolve their marriage or nullify their marriage. The right they have is that they can move to the court for a divorce petition based on this ground. So, now personal law and territorial law. Hindu law and Muhammadan law were comprehensive systems. That comprehensive means they not only covered the personal laws, but a huge, different kind of laws. Like they dealt with all branches of law, such as criminal law, contract law of evidence, etc. The territorial law superseded the personal law in these fields. So personal law acts only in the narrow field which was not being covered by a corresponding territorial law. So what will be covered here? It will be like laws relating to inheritance, caste, marriage, other religious usage or institutions. So this can be uh, seen clearly or understood clearly in the following slide. So personal law, what does the personal law deal with? So it's mainly succession or inheritance and marriage or divorce, guardianship, maintenance, joint family and partition, adoption and religious endowments. Now, removal of obnoxious customs. So what are obnoxious customs? These are those customs which had a very bad influence on the social uh, economic status of people. These were mostly against women. So few example will be like abolition of sati, that was in 1829. Then Hindu Widow Marriage Act, that was in 1856. These are like two of the examples where removal of obnoxious customs were applied. Then what does our constitution makers really wanted. Like we have brought personal laws, but was it really the intention of the constitution makers? We can say partly yes and partly no, because we like India, a country with multiple religions and a very diverse people, we needed to bring all the people under, and we cannot force something to these people, so we needed personal laws. But meanwhile, it was also the intention of the constitution makers and others, the founders, uh, to create a space where there's a uniform civil code. But this was not like practicable to be implemented all of a sudden. So this was put in as a DPSP, that is Directive Principles of State Policy, under Article 44 of Indian Constitution. And here it says that the state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. So what exactly is a uniform civil code? When a uniform civil code is there, the personal laws will come under uniform civil code, and there will be no distinction between whether it's a Hindu law, a Muslim law, or a Christian law. A Hindu, Muslim, Christian, Parsi, whoever they will be dealt with the same uniform civil code. So that is what is intended by the constitution makers when they stated it in Article 44 of Indian Constitution. Now, nature of Hindu law. So Hindu law is an ancient law. It dates back to centuries and centuries. The roots of Hinduism goes way back. Uh, we can see from the start of civilization in India, and then it's divine in nature. It's not a man-made law. It is supposed to be something that was as a word of God that is given down, passed by the word of God heard by the rishis or munis. They passed it down to other people. They educated other people. The knowledge passed on from generation to generation. So it's divine in nature. And the Hindu law also includes the customs, beliefs, and judicial interpretations, etc. So here, when we are going to start with the Hindu code, before we discuss about the sources of Hindu code, we should understand the Hindu code. So, Rao Committee first put forth the Hindu code, like in 1947. That was where, like, even before the first, as we discussed earlier, the first statute in Hindu personal law was the Hindu Marriage Act, and that was in 1955. So, even much before that, in 1947, the Rao Committee had put forth the Hindu code. And this Hindu code was a very comprehensive code. It included all the aspects of Hindu personal law, but it was not able to be enacted since the parliament was dissolved before the assignment of the bill, and it was not enacted. Later, this Hindu code was implemented in stages in four installments. Though the first one was the Hindu Marriage Act in 1955, then came Hindu Succession Act in 1956, then the Hindu Minority and Guardianship Act in 1956, then Hindu Adoption Maintenance Act in 1956. So all these four were actually based on the Hindu code put forward by Rao Committee in 1947. Here we have to note that the civil marriage were not a subject of Hindu Marriage Act of 1955. That was brought under Special Marriage Act of 1954 with effect from 9/10, 1954. Hindu Marriage Act 1955 was extensively amended in 1976 with the presidential assent on 27/5, 1976. So when we consider regarding other exams, law related exams, and our considering our problems, we need to know since when an act came into effect. So considering that Hindu Marriage Act of 1955 came into effect with respect to 18/5, 1955, that is May 18 of 1955. Now, Hindu Succession Act came into being in 17/6, 1956, that is June 17, 1956. Hindu Minority and Guardianship Act 1956, it came into effect on 25/1/1956, that's January 25th, 1956. Hindu Adoption and Maintenance Act came into effect from 21/12/1956, December 21st, 1956. Now, sources. We have traditional sources and modern sources. So before we discussed about the Rao Committee putting for the Hindu code. So that Hindu code was based on the traditional sources as well as modern sources. We cannot purely depend on one kind of source. So we have multiple sources, and that is traditional as well as modern. So let's see what are the traditional sources here. Those are Shrutis or Vedas, Smritis, Ajara or usages, commentaries and digest, then justice, equity, and good conscience. And justice, equity, and good conscience refers to the natural justice. This is a traditional source as well as a modern source. Now, coming to the modern sources, we have Mitakshara and Devbhaga schools, then customs, precedent, and then again justice, equity, and good conscience, which are principles of natural justice. Now, Shrutis or Vedas. Shruti refers to that which is heard. Vedas, it is also known as Vedas. Vedas means knowledge. Here, the words of the gods heard by rishis or munis were passed on from them to their followers, students, and from them to the other people. So the rishis and munis are those people or sages who worshipped and indulged in meditation in search of higher truth or knowledge. Now, Rig Veda, which consists of the hymns, is the oldest of the Vedas, and Yajurveda, which consists of sacrificial ceremonies and anything that is related with sacrificial rituals. Now, Samaveda dealt with music and chants, and Atharva Veda, which is the last of the Vedas, dealt with the application of the Vedas or the knowledge. And Atharva Veda also included Ayurveda. Then we have Smriti. It is also known as Dharma Shastra. Here, Shruti is something that is remembered. So in Shruti, we said that it is something heard. That is, the rishis or munis heard the words of the god and passed it down to their students or followers. Now, here the sages recorded what they heard from the god in their own words, and this is what is remembered called the Smriti. Now, this started a systematic study of Vedas. Now, what is Vedas? They are knowledge. So, all of these discuss about two subject matter, that is Vyavahara or the etiquette, how a person should behave in a society, and Prayashita, in case a person has done something wrong, what shall be done? How can the person make it good to the other person, etc. Now, Manu Smriti, Yajnavalkya Smriti, and Narada Smriti. These are the Smritis that are mostly discussed when we discuss about the sources. Now, the oldest among them is the Manusmriti. It has 2694 slokas and it was set in 200 BC. And this Manusmriti is the one that has the paramount authority with 18 chapters. And these 18 chapters discussed about all kind of subject matter, that is all the Vyavahara as well as Prashita. Like the chapter 1 was recovery of debts, what we currently discuss in Contract Act or Special Relief Act. Now, I'll give a small account of what were discussed in Manusmriti. So it has 18 chapters. So 1, recovery of debts. 2, deposit and pledge. 3, sale without ownership. 4, concerns among partners. 5, resumption of gifts. 6, non-payment of wages or hire, and so on. So we see that most of these are dealt with the contractual liabilities and the reliefs. In Manusmriti itself, when we have chapter 10, which discuss about dispute regarding boundaries. Now, here we have come to a civil laws. It's a dispute between boundaries. Then chapter 9, dispute between master and servant, again contract law. Then in chapter 11, we discuss about assault. Chapter 12 about defamation. Chapter 13 about theft. So here we have started with the criminal laws from chapter 11, assault, chapter 12, defamation, chapter 13, theft, chapter 14, robbery and violence, chapter 15, adultery, chapter 16, dispute of man and wife. So here we have come to family law too. Then we have partition, gambling, and betting, and so on. So these smritis dealt with all kind of laws, that is contract law, criminal law, civil law, then family law. And now Yajnavalkya Smriti. So here Yajnavalkya Smriti had 1010 slokas, and here the wordings were direct and clear language, very logical language. And this was written in the 2nd century AD and had 4 chapters. And these chapters were the chapter 1 was Acharas, which includes also marriage. Then this chapter 2 was Vyavaharas, the etiquettes, the trades, all this. Then chapter 3, Prashita, the like the crimes and the punishments. And the chapter 4, Khandas, which also dealt with the courts, procedures, theft, adultery, debts, pledges. So here also we see that the Smritis, even the Yajnavalkya Smriti, dealt with all kind of laws. That's what we discussed in the beginning, that Hindu law in the ancient time was a comprehensive system, and from there we adapted only the personal laws for Hindu law as it is existent right now, and all the other laws, general laws, were brought with general laws. Like we have legislations for that. We follow it, not personal law. Now we have Narada Smriti with 18 chapters again, and it was written in 4th century AD. So going further, we have Achara or usage, or we can also say as customs in traditional sources. So here it should be a continuous practice in a society. And here two things were considered: Shishtachara or Sadachara. What is an act that is good for the society, and what is a act that is not good for the society. Now we have commentaries and digests. Commentary explains a particular smriti, and digest explains a collection of smritis. So it had a collective knowledge. Now, the contradiction in various smritis led to the need of commentaries and digests. So, we discussed earlier in smritis that Manusmriti, Yajnavalkya Smriti, everything dealt and spoke about the same subject matter, but it was not both exactly the same. There were contradictions in the rules and the principles, and these led to the need to have commentaries and digest. Now, justice, equity, and good conscience. This principle is existent in both ancient as well as modern times. Now, Vijnaneshwara of 12th century, a jurist, and Yajnavalkya, an 8th century rishi, are well known in this field, and they were the persons who prominently applied this principle in their decisions, or when they brought a dispute or any aggrieved party into a settlement. Now, when there is an absence of any provision in the Smritis, this principle was used. So, when there is an absence, we cannot just leave a dispute as such as. So, we need a resolution, and for this resolution, this principle was used. That is justice, equity, and good conscience. And this is the same principles that we learn under natural justice in the present days. Now, Mitakshara and Devbhaga school. So, moving on to the modern sources, we have Mitakshara and Devbhaga school. So, in Hindu law, we mainly discuss about two types of schools, that is Mitakshara and Devbhaga, where Devbhaga was in a limited state, that was mostly in West Bengal, Assam, etc. And Mitakshara school was the most accepted school. Here, Shastric laws are also known as Nikhandas. So, these Shastric laws are rules and principles of different smritis. Now, these commentaries along with the digest form the Nikhandas. Mitakshara is based on the commentary of Yajnavalkya Smriti written by Vijnaneshwara in 11th century, and Devbhaga school was based on the digest written by Jimutavahana in 12th century. Now, custom or usage. So, what is a custom or usage? It's a habitual course of conduct generally followed in a society. So, it's not something that one person comes up with. So, this is something that has been in practice from ages to ages and has been given down from one generation to another and every generation henceforth. Now, the transcendent from one generation to another is ongoing and never ending. Achara Paramo Dharma is what is referred in Manusmriti regarding custom or usage. Now, here custom and usage can be classified. There were caste or class custom, family custom, and local custom. So, what is a caste or class custom? So, Hindu law, under Hindus, we have multiple castes, and each caste has a different kind of custom. The customs they follow in a marriage, in divorce, in inheritance, in succession, and so on. Now, family custom, this is confined to a particular family. What is the practices followed by a particular family? Now, local custom is something that more territorial. If you give if you are considering an example, in Hindus, the customs that is followed in South India is different from most of the customs that is followed in North India. So this is something that is based on the territory and can be considered as a local custom. Now here we need to discuss about Ramnath case, which we'll discuss by the end of this video. Now precedent. Now precedent deals with the court of records. So what is a court of records? So if so decisions of the courts, that is the high courts or Supreme Court, that is those come under court of records, are recorded and these have evidentiary values. And if any person is going against this decision, that will be contempt of court. So when there is no statutory provision or no law made on a particular subject matter that is in question, we follow precedents or we form precedents. So when a new situation arrives and the court can't just leave the situation saying that, sorry, we don't have any statutory provision for it. We cannot do that. So here, based on the principles of justice, equity, and good conscience, the principles of natural justice and other doctrines that we follow in the judiciary, they come up with a decision. And when there's a similar situation again in future, the same decisions will be used. That a decision taken in one case with similar facts will be used in another case with similar facts. So here, this is mostly based on the doctrine of stare decisis. The doctrine of stare decisis will be explained in detail in another video, but the precedence is based on doctrine of stare decisis. Now, justice, equity, and good conscience. So, as I said earlier, this is a source of law in traditional as well as modern law. These are the principles that is based on natural justice, and these are used when there is an absence of any specific law or usage. So, as we discussed earlier, it's not just the statutory provisions or enactments that we look forward. We also give value for the customs. So when there is no valid custom or there is no statutory provision for a particular subject matter, then we go for the principles of natural justice and make a decision that is completely based on justice, equity, and good conscience. Now, case laws. Regarding case laws, we have Collector of Madura versus Muthu Ramalinga Sedupati. This is also known as the Ramnath case. That is in 1868, 12 MIA 397. So here what happened was the Zamindar who passed away and the wife of the deceased adopted a son. So later the collector sent a notice to the son saying that when the widow who adopted the son or the wife Parvati, when she passes away, the property of the Zamindar will be taken by the government, will be given to the government as the adoption was made after the death of the husband and this cannot be considered valid. So this case was moved to the court and the Privy Council went through different customs, and the Privy Council found that we have Mithila school, we have Maharashtra school, we have West Bengal school. There are different schools. You have to notice that this is a case that came in 1868, that is before actual codification of Hindu law. So the Privy Council went through the different schools and then said that uh, after considering all the school, here we have to consider the school that is applicable in their territory, or what is applicable to them, their family. And in that respect, even though the husband has died, has passed away, when the widow adopted a son for the purpose of carrying on with their, uh, passing on their property to them or carrying on their family line, this can be considered as a valid adoption, and it is fair to give the property to the adopted son, and the government shall not acquire the property. So that was held in this case. And then we have another case, Abraham versus Abraham. Here, the court held that no matter what the belief or how the people are living their life right now, the court said that so long as a person remains as Hindu by religion, he is necessarily governed by Hindu law and it has an obligatory force on him. That was held by the court in Abraham versus Abraham. So these are just few of the case laws. And here, for reference, I have used the textbook of Family Law in India by Professor G.C.V. Subbarao, that is 10th edition of Narendra Goji and Company. And this is a textbook that explains very well regarding um, different provisions, and it is also in commentary form, that it explains each sections of various barracks that is related under personal law. It covers Hindu law, Christian law, as well as Muslim law in a single textbook. So I referred this textbook for creating this video, and it is a pretty nice textbook. Plus, I also have referred to the lectures of Bindu GK ma'am, who is an assistant professor of Government Law College, Trivandrum. And thank you, ma'am, for and thank you. So thank you, everyone. Please like, share, subscribe, and comment on our videos, and let us know your feedback or the topic on which you would like to see a video or presentation from us. And if you find anything that is missing from this video, or you would like to add some points to this video, then please note it down in our comment section. So those all who are watching our video can also go through the comment box and check if I have missed out any topic, so that they can update their notes and use this to prepare for their exams or any other, to create a basic knowledge regarding this topic. And thank you everyone for listening to me and for following my channel. We'll see you again in next video. Until then, bye bye, take care.